The Supreme Court will today analyze if telecom companies currently under liquidation are faking their bankruptcy to avoid paying AGR dues of over rupees 40,000 crores. On the previous date of hearing, the top court had asked the DOT to file its reply and submit details on the approval which was given to Reliance Jio to use the spectrum earlier allocated to Reliance Communications. A three-judge bench led by Justice Arun Mishra had observed that revenue will be wiped out if the spectrum is sold, and the person or the company using the spectrum should be made liable to pay AGR dues. It had questioned why Reliance Jio should not be asked to pay AGR dues which are to be given by Reliance Communications, since Jio is using the spectrum which was given to RCom since the past 4 years. Also, both telecom companies have been asked to file details of their spectrum sharing agreement, while resolution professionals for Aircel and RCom have been asked to submit details on the use of their spectrum and the details of the entities which placed bids for these bankrupt telecom companies under the Insolvency and Bankruptcy Code. The top court had indicated that it wanted to know who was behind the bids for Reliance Communications. The court is yet to rule on the timeline of AGR payments by telecom companies, a decision keenly awaited by the telecom and the banking sector. Earlier, the DOT was pulled up for not filing an early appeal against inclusion of spectrum in assets by telecom companies, over which the court had questioned how would the centre recover AGR dues if telecom companies had already sold off the respective spectrum which was allocated to them. The top court had observed that it wanted to know the cause of initiation of insolvency for telecom companies under IBC and will see if there was any urgency in pushing for insolvency to avoid paying unpaid AGR dues of over 40,000 crore rupees. Appearing for the DOT, Solicitor General Tushar Mehta had rebutted the asset classification which was made by RCom and Aircel, where spectrum was counted as part of their assets. He had argued that the tribunal ruling in favor of RCom was already under challenge in the top court on the ground that spectrum is a natural resource which can only be allocated by the government but can't be sold by private players. DOT had informed the court that Aircel's resolution plan was finalized, while RCom's resolution plan was on the verge of being finalized. Representing RCom's resolution professional, senior lawyer Shyam Divan had submitted that the company's monetization process outside IBC had failed due to lack of consensus between different lenders, while he submitted that RCom's insolvency process began after claims were made by China Development Bank and Ericsson. The court asked, how could Ericsson drag RCom to insolvency when its settlement amount had already been paid? The court had also expressed its ire on NCLAT reviving insolvency proceedings against RCom despite payment to Ericsson being made in consonance with a top court order. RCom's resolution professional had informed the court that the resolution plan was pending NCLT nod after being cleared by lenders, and they counted spectrum as the telecom company's prime asset against liabilities of over 49,000 crores owed to banks.